Hi, everyone. Harry here to talk about another U.S. attorney having been found to be invalidly appointed, very much like the factual scenario involving Alina Habba in New Jersey. And I think we're going to start to hear the drumbeat today. The new appointee, Lindsay Halligan, in the Eastern District of Virginia, who has just indicted Jim Comey. I wrote about this and the law in my Substack from Tuesday yesterday if you want a little more sort of legal arcana. And this is a matter of legal arcana in certain respects and makes people's head spin. But let me try to simplify. Congress cares a lot about who becomes a U.S. attorney or a judge or whatever. U.S. attorney in particular, it's a political plum on the one hand, but it's not a lifetime appointment. And so especially senators of the state where they're appointed, they want to weigh in. I can give my own example. I was appointed by the president to be the U.S. attorney in 1998. Arlen Specter, the Republican senator from Pennsylvania, had nothing to do with it, really, and being a Republican and not having sway over the White House. But when it came time for me to be sworn in, he trotted down to Pittsburgh, took total credit for it. It's a political plum. Okay. And it's a plum that the Senate doesn't want taken away from them. And that's what really is the explanation of these labyrinthine provisions. There are two laws in play that dictate that once an appointment has had a certain kind of thing, you can't do this, you can't do that, or you can't put this sort of person in. Okay, and to summarize the essentials of the law, you can do, and it often will happen early in an administration, that they will do because they don't have anyone confirmed as of now. Trump had almost no U.S. attorney confirmations. You can put somebody in as the interim U.S. attorney for 120 days. You can do that. But when those 120 days lapse, you're done. And the scheme says, and this is Congress wanting to be sure that administrations don't just do end runs around their congressional prerogative and say, okay, we'll make this person acting for the next 8 years. What do we care if it's acting or otherwise? And so the law is at that point, the court appoints the U.S. attorney. And that's what happened, of course, with Habba when they appointed Desiree Grace, not Habba, and that's caused all the hubbub there. And for the Congress, that's fine. The court has this sort of placeholder U.S. attorney who can act presumably for professional reasons, no political credit, anywhere. And then that person can stick around until there's a confirmed nominee. In other words, when you go through the process and you do the whole political thing, which you haven't been able to do so far, that's the reason you have an interim, then that's it. You get to do your thing because then Congress weighs in on it. If to be confirmed means Congress has weighed in on it, and that's all good. Okay. There's another law, the Federal Vacancy Reform Act, and it basically says, there's a little bit of dispute. This is going to be working up now from 3 or 4 courts, but what it basically says is, well, first, the statute that provides for an interim appointment as interpreted by courts, it's clear you only got one of them. After 120 days, you can't do another interim. That would permit an end run around Congress. So you only got one. And at that point, says the Federal Vacancy Reform Act, you can't just put anyone in. You can do, in certain narrow circumstances, an acting United States attorney after the interim appointment has run. But it's narrow. It's got to be either the already, and it's one that either provides for some kind of input by Congress or at least make sure it's not just a, political crony appointment. So you can put in either a first assistant U.S. attorney who's been there and is ready to take the reins, et cetera. That's not really perverting the professional structure. Or someone who has been Senate confirmed to another position, could be in another agency, but that at least suggests that the senators and others have scrutinized her or him and have a proxy for their input. Or at a bare minimum, somebody with sort of 3 or 4 factors, but one of them is you've been in the Department of Justice, the place where they're going to appoint you, for at least 9 months of the last year and the like. Okay. Haba, none of these things is true. And she is out. And we have a hot mess in New Jersey where the court has basically said not just any indictment she signed, anything she supervised. A defendant came forward and said, she signed my indictment. She's not a legit U.S. attorney. This wasn't a legit indictment. Set me free. And right now it's really unclear what's going to happen in the District of New Jersey, and certain courts outside the district are trying to figure out in those individual cases. Brings us back to Nevada, where yesterday the judge said more or less the same thing. Your interims run out. The person you're trying to put in wasn't the first assistant, hasn't been there 9 months, isn't someone who's already been Senate confirmed. Indeed, whether this is a coincidence or not, every time it's come up, it's because Trump has been looking to install some complete amateur lackey with no experience. That's certainly the Lindsey Halligan situation in the Eastern District of Virginia. It's the same in Nevada. So the judge goes through and says, I agree with the defendants here, and you're not one of the 3. You are out. And that means you can't oversee, not to mention work on, but even be the supervisor for any criminal action. Now, unlike the judge in the Haba case, which have said, this could be all null and void, and what a headache. The judge in Nevada has left room open to say something like, you can re-indict those people who are before me, but you have to make sure that this U.S. attorney who was not properly indicted or not properly put in there, a woman named Sigal Chattah, doesn't supervise at all. So in other words, that judge is saying, all right, we're not going to, less severe than the judge in New Jersey. We're not going to just throw out everything. You may have a way of still, keeping criminals, if you prove them to be criminals, as you've alleged, in the system, et cetera, as opposed to just saying they have to leave. Okay, so that's the news, what happened in Nevada, but it brings us directly to Lindsay Chattigan in New Jersey. So it looks to me, I was out there, dear listeners, a couple days ago on the limb here, where I think I have a lot of company, but it looks to me as if Halligan has the same problem. There was an interim appointee. The 120 days was served. They just stuck her in Tuesday, and she had to go, not knowing probably where the water fountain is, she had to go and handle the indictment before a grand jury. Is she someone who's been appointed before to a Senate position? Is she the first assistant in that office? Is she someone who's been in the DOJ 9 months of the last year, et cetera? Try barely 9 hours. So to me, she flagrantly doesn't meet the criteria of the FVRA. Now, what that would normally bring up, and does in other cases, and Nevada versus New Jersey is the perfect illustration, is, okay, now what? There are things that she has overseen or been, at worst, the signator on of an indictment. And do we, as they're saying in Nevada, maybe put together a way that even though she would have to be walled off, you could still charge those people? Or do we do it the way they're doing it in New Jersey with Haba and saying, man, all bets are off and all these indictments are in doubt, etc.? And the answer is, it doesn't matter, because as of this morning at midnight, the statute of limitations ran on Jim Comey's alleged crime. So if the court finds that Halligan was improperly appointed, there's no way to cure it, I think. I mean, they can try to make a creative argument of we can do it later and refer back and revive or sustain the statute of limitations. But man, if you could get away with that, what would a statute of limitations even mean? So if I'm right that she's not qualified, I think this is one of I wrote on Monday 10 fundamental flaws, and this was one of them. And there are many ways that I see this case imploding and coming to naught, and it really should. It's the worst thing that a Department of Justice could do, indict a political enemy of the president at the president's order and without evidence. The worst thing a prosecutor can do. This is one of the ways it could, in fact, implode and come to naught. So it's going to be really interesting. And you're seeing just this morning much more commentary. And maybe they've known, but have held their fire to not give the tip off to DOJ. But it is now too late. So this is slightly delicious, you could say, not a very objective commentator's point, but it's so rank what Trump did here. And if it turns out they screwed up, knowing what the screw up is, because they did it before with Haba, and that means that the case ends as it should as a debacle and in humiliation, well, I'll cry no tears here. It's a really terrible travesty of justice. Okay, so there you go. What's happened in Nevada, how it's a little bit different from New Jersey, and most importantly, what all of this has to do with the totally rank, nasty indictment of Jim Comey. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.